Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Oh, that's so good. Good morning, everybody. Hope this finds you well. I was in the mood for a little country this morning. Oh, I can hear myself now. Good morning, everybody. Welcome aboard. Today is going to be an interesting day. Good morning, oh sunny day. And Angela, welcome. Yep, you know the routine. You've already done the like. I haven't even got the thing up yet. Give me a second. Oh, there we go. How are you doing this morning, y'all? Let's see. Yay, I can do 2 different streams this way. Y'all, I'm learning. I'm a learning. I am going to be double streaming today. Uh-huh. So what we're going to do is when the love affair murder trial pops up, we are going to have that live, and then I'll have this live running for Verdict Watch. We are on Verdict Watch. Here we go. There it is. How are y'all doing today? Oh, thank you guys for liking it. Man, last night, I don't know why I was so tired. I was just like, and I went home and I was in a lot of hurt from arthritis. So I took a new medication the doctor gave me that's supposed to help take away the night pains, and it helps me sleep a little. Oh, did this girl sleep? I didn't want to get up this morning. I was going to try and be here at 7:30. Yeah, it didn't happen. Sorry, guys. But we are on a Verdict Watch. Let me share screen. There it is. Let me get it up and blown. I want to see if there's anything that happened in court, any questions that may have happened. Oh, there was some stuff. So let me get it on screen and let's do the Trying to think. My brain is not engaged yet. There we go. So let's get that playing, get some sound on. Zoomy zoom. And let's see what the courts had to say. Oh, my mic is driving. I've got to get it tighter, and I don't have the strength.
So we're squared away.
That's her parents.
Okay, I just wanted to double check. Thank you.
That's a miserable place to be for a loved one. Even if they did do it, it's a horrible place to be.
Yeah. Well, sometimes I confuse myself. Let me explain the situation with the alternates. You never know when a regular juror is going to get sick or have a problem with a relative or something come up. And that's why I had the alternates come back today. And I'm going to excuse them. I thought about the possibility
one of the people may fall out
in case we have to do a mercy trial, but I don't think that would be appropriate because they won't engage in the regular deliberations.
Sorry. So having bad hair day.
We're going to go ahead and excuse them. That they have told the bailiff that they want to stay. We have a very good jury that's extremely interested in the proceedings. They're not grumpy, they're not complaining, and they are fulfilling their civic duty. So we can go forward and hopefully we'll have the regular jurors, less the alternates shortly.
I would never release all the alternates.
And I'm saying if there is indeed a mercy phase and one of the jurors gets ill or something should happen to a juror during the mercy phase, then the mercy phase cannot be decided by 11 jurors.
This is true. That's why I contemplated the possibility of holding them, but keep in mind they will not engage in the regular deliberations, which may or may not cause us any problems. And the others will be ahead of the game in that regard. And I'm not sure that it would be entirely appropriate to use them later if they have not engaged in the rendering of the verdict. Now we can impanel a new jury simply for the mercy phase. I don't think that's the best idea. I would prefer to use our regular jury that's
then
familiar
don't
with
release
the
alternates,
because
dude.
if we impanel a new jury, and all of this is contingent upon a guilty verdict, of course, but if we impanel a new jury, we've got a new trial. We have to cover a lot of ground.
I would not release the alternates. I'd put them in a separate room and tell them don't talk.
And we're way ahead of this, but just talking about
right.
If there is not a unanimous verdict, then you redo the penalty phase with a different verdict, different jury. That's really what we're talking about here. So I think the court
don't release.
Could take the two alternates, instruct them as to what not to do until they're fully released. And then if you need an alternate at either phase, they're available.
And they can be contacted. The only issue is that if they want to stay here, they cannot be exposed to any.
Well, and they do want to stay here. They've told the bailiff that they want to stay, and that's why. And of course, I can kick them out and
Tammy,
tell them to run like turkeys.
I love these people. You know, I can kick them out and tell them to run like turkeys before you get shot for Thanksgiving dinner. What they're discussing is whether or not the two alternates should be released or should they stay. And I think that, hi, Rhonda, welcome. So they're trying to decide, should the alternates be released or stay? Hi, Trash. I mean, Tash. I'm looking at trash. I got to take trash out today. Today's garbage day. So, Tash, welcome. Love you. Thank you for I liked. So, they're discussing whether or not the alternate jurors need to stay or go and that process. And the judge just said, well, I don't know if I should let them out and tell them to run like turkeys. You've been watching this trial. Well, thank you very much.
Home, but you know,
I'm going to be running
The-
2
the-
lives at the same time in a minute.
Right. They want to.
Well,
Yeah.
they would of course have to be isolated from any potential outside influence, and I think that can probably be done. And
Well, let me ask this, and we're
Why
way,
are you asking this? You're the judge. You guys are 2 alternates until this sentencing phase. Obviously, the jury's going to decide the sentence. You guys need to stay. We have a separate room for you. Please go and make yourselves at home. End of discussion, y'all. Sorry, I can't
ahead
help talking like them.
Proceedings.
Good
but
afternoon,
in
Haley
the event
Mom.
there is a guilty verdict, a first degree murder, I would envision going straight into the mercy phase,
Natalie
if not
Cochran.
this afternoon or whenever the verdict is rendered, at least tomorrow or Friday. Are you folks contemplating coming back in 30 days or?
The state believes that the court's procedure as stated is correct. There would be a verdict, timeout to get organized, and then
Do verdict and go straight into sentencing.
I
Period.
agree on.
Okay. And could you folks be ready as early as this afternoon, if need be, if we have to go into that phase?
Mr. Selden will.
Your
I'm
Honor,
sure enlighten the court.
we've anticipated some of these problems. We would need at least 2 hours to get together our witnesses at a minimum.
Well,
So
2
then
hours
it'll be
would
tomorrow.
fair. I don't have any problem with that. I just don't want an extensive delay because it's unfair to the jury and it's unfair to the judge.
Oh,
But
boo.
again, we're talking about possibilities, and we don't know what will develop, obviously. But is it the suggestion then that I hold over the alternates in case we need them for a
Yes,
mini
you
trial?
wanna.
No,
the state would suggest that the court follow its standard procedure, instruct them, turn them loose to wherever they want to go.
Just release them.
I think so, though. I mean, that's what the court's done in the past.
That's what I've always done. But I know that Judge Hutchison on several occasions would keep the alternates.
Keep them.
And they would moan and groan about it.
As well they should. It seems you would get the benefit of their availability as an alternate while not making them just sit around in an isolated room in the courthouse.
Yeah.
Your Honor, I need to backtrack for just a moment.
Okay.
I stated to the court we would need at least 2 hours. Unfortunately, we're anticipating calling certain witnesses, and they would need not 24 hours notice, but they would not be available the same day. They would have to be contacted for the next day.
Okay. Well, let's see how it goes. We need to cross that bridge when we come to it. This is what I have decided to do.
No.
I'm going to release the alternate jurors outright. I think it's unfair to keep them, and we'll deal with the situation. Hopefully, we'll have 12 that will continue to participate if we need them. If we don't, we'll just have to impanel a new jury. It's
That is
rolling the dice.
stupid. I wish I had my soundboard working.
If that's
That
the court's
is-
decision, that's it. But this court has
Starting to feel like this
sent
is
jurors home with
hillbilly
instructions,
court.
send them wherever they want to go with instructions, and they're still available. You could inquire if their service is needed as to whether they fulfill the court's instructions, and that way in the event that we're short, we don't have to start this all over again.
Your
Oh
Honor,
my, that sounds
on
reasonable.
behalf of the defense, I would object to that. There's been a possibility of jury contamination all through this case. We discussed it in depth. I believe these jurors, once the alternates, once they're released, they're going to feel like, okay, we're not on the jury anymore. We can discuss this, etc. I think there's just too much risk of contamination.
Well, that's my fear too. And
Well, why don't you just hold
gonna
them for
follow
the afternoon?
normal course of conduct, and I'm going to release the alternates, and we will see what happens thereafter. All right, are we ready for the jury?
Yes, sir.
Yes, sir.
Bring in the jury bailiff.
Bring the jury.
Give them it. Well,
And one
give
thing
them
I'm
books to
thinking
read.
about, this
Give
is a
them
really good jury. We
movies.
haven't had any problems except at the very outset. They've been here on time, and they are prompt, and I've been watching them. They've been listening to the evidence carefully, and so I have confidence in these folks.
I have confidence in them, but I don't have much confidence in me. I should have just made the decision as the judge. And the decision is you stay. I'm not trying to be tacky, y'all. I'm really, really not.
And I
But
got them
sometimes
sausage
it's just
biscuits this morning too.
mind blown.
That's why they want to. That's why they want to stay.
Stupid is as stupid does. I'm sorry. I'm really getting weird. It's a morning. I slept so good.
Good morning,
I
ladies
took
and
some new
gentlemen of the
meds for
jury.
discomfort and
How
oh
are
my
you all
gosh,
doing?
great.
I understand you're getting along very well from
Out of
what
bed.
the bailiff reports, and he says that you are happy and agreeable with each
Oh,
other.
welcome to
which is always
kindergarten. Thanks for
pleasing
getting
to the
along,
presiding
y'all.
Judge. We have reached almost the very end of this trial. This is the sixth and final stage of the trial. And as I explained,
Do we
to
actually
you
have a verdict?
yesterday
Let me go
evening,
double look.
this
I got to
will
get that
be
out of my
the
mouth.
deliberation
No, they don't
phase,
have a
where
verdict
you
yet.
will retire to your jury room to deliberate on your verdict. And this will be the first time that you can fully and freely discuss the case, because I've been mean to you all along. I haven't been able to let you do any discussions, and I know you've been dying to talk about the case among your
Yes,
fellow
I have.
jurors, but I haven't
Hilton,
let you
thank
do it, and
you.
I've been like a broken record telling you not to talk among yourselves or with anyone else about the case. Before I send you into the jury room, I have to release the alternate jurors, and you folks have been just as wonderful as anyone else, and you have come and attended, and you have done everything required of you. Of course, your job would be to fill in for a regular juror if somebody got sick or someone had an accident or for whatever reason couldn't continue to serve. Then we would energize the alternate juror or jurors, and they would become regular jurors. And you saw this happen once before at the start of this case. So Haley Austin and Karen Buckland, where are you folks? Are
Why are you
alternate,
giving out their
jurors.
names?
And let me explain the situation. You can hang around if you want to, and you can wait.
Well, thank you,
and,
Your Honor.
see what the verdict is in this case, since you've got a vested interest in it. You can run like turkeys home and watch the
Run like
Price is
turkeys
Right
being chased for
and some of the
Thanksgiving
other
dinner.
shows on TV. And you can call up here if you are curious, and call Judge Polling's office. This is his courtroom now, and he will tell you, or his secretary will tell you the verdict. So
Thank you, Rachel.
you're free to do that. Now,
Yeah, feed them.
lots of people will want to talk to you, and obviously your family members will want to ask you questions about this trial, and you're free to talk to them about it, and you're free to watch accounts about the trial. I'm speaking to the alternates. You may have other sources, streaming sources, that will want to interview you, and that's entirely up to you. You don't have to speak to anyone. If someone would approach you and want to have you do a survey, or even appear on camera, it's up to you. And if you don't feel comfortable with that, you can say no. I don't want to talk. If you do feel comfortable, you can, and
I
I'll
want
give
my
you my
15 minutes
permission
of
to
fame.
do so. And I don't have anything else to tell the two alternates, Ms. Except my sincerest thanks for coming.
Thank you for muting it
and
this time.
participating. And I'm sorry that you weren't able to finish things out and continue by deliberating on the verdict. So now, Ms. free to go with the bailiff to the jury room and to depart, or wait on the premises as you wish. Thank you very much. Thank you. Thank you.
I will give you your certificate of appreciation later. Thank you very much, ma'am.
Now, the business is
Ma'am.
at hand for the rest of you folks. You will, as I say, go to your jury room to start your deliberations. And the first thing that you should do is to select a jury four-person. And you note that I say four-person instead of the incorrect and outdated term of four-man, because obviously it can be a four-woman or four-man. It's a
Thank you
person.
for that
Now,
clarification.
that
We've
person's
come out
job
of the 1950s.
will not be any heightened. You won't have a heightened vote or a more important vote than anyone else, but you will see that the deliberations are carried out in a proper and orderly fashion. And most importantly, once a verdict is reached, you will sign as four-person of the jury the verdict form. And we have worked very diligently to make this verdict form as understandable and simple as possible. It's 2 pages.
Did you bring it down
I'm
to a
going to
third
give it
grade
to
reading
you,
level,
obviously,
Your
put it
Honor?
on the very top of the exhibits and the documents that we send in with you. And you may wish to pass this around initially so you can see it. It will help focus your discussions, perhaps. When you reach a verdict, you should turn on the light. The bailiff will show you the switch, and the bailiff will come in and gather you up and bring you back into the courtroom. The four-person should hang on to this verdict form, make sure that it's filled out appropriately and that it constitutes the true verdict reached by you all. And today's date, today is January the 29th. Presumably you'll reach a verdict today, but you may come back tomorrow, which is perfectly all right. But whatever date you do reach the verdict, you should fill out the date and sign it appropriately. Then when you come back in the courtroom, the four-person should hang on to this verdict form, bring it in, and the bailiff will retrieve it, deliver it to me, and I will read into the record your own true verdict. Now, I can't give you any hint at all as how to decide this case. I can discuss procedure if you have any questions about deliberations in terms of mechanics or anything like that. Does anyone want to tell a joke that hopefully
really?
that I'm not the butt of? No jokes. Okay, Well, this is serious business, and I want you to get started and get down to business in this matter. We have all the exhibits there, Madam Clerk. All right, we have boxes of them somewhere. And ladies and gentlemen, I'm going to put this jury charge on top, and on the very top will be the jury verdict form, and the clerk will make sure that they are right there for your viewing and review. All
When
right,
they go back,
members of the
I
jury, you
have a
may
video I want us to
follow
see.
the bailiff to your jury room and commence your deliberations. Okay.
So there's another trial.
Permit me to
Gwinnett
thank
courtroom.
all counsel in this case for your cooperation, your patience, and your consideration. It's been a pleasure dealing with all of you in this matter. This has been a trial of no serious problems or issues, and you folks have made
Good.
it
So
that
I'm
way. You
giving
folks
y'all's
have
an
been
A for good
excellent to work
behavior.
with, and I express my sincerest thanks to all of you.
Power
Now,
and forward.
you can remain on the premises. If you wander away or go back to offices, give Sarah a number where she can reach you, because we'll need to gather quickly.
Okay, so that's where we are. We're going to zoom. There was no questions, but we're going to come over to this video. Oh my gosh, y'all, this video I hear is interesting. Now these people, there's 3 gentlemen, and I use that word very loosely, are on trial for unaliving their a coach, and this is the sentencing phase.
Mr. Collins,
There is some commotion I
count
hear.
1. Excuse me. Count 1, which is felony murder. Predicate act is aggravated assault. I sentence you to life without the possibility of parole. Count 2, which is violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 1. Count 3, violation of Street Gang and Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 2.
You're gone for life, boo.
Count 10, hijacking motor vehicle. I sentence you to 20 years consecutive to count 3. Count 11, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 10. Count 12, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 11. Possession of a firearm during the commission of a felony. I sentence you to 5 years consecutive to count 12. Count 14, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 13. Count 15, which is a violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 14. Mr. Collins, you have now been convicted of 15 felonies, but sentenced to 9 because 6 of them by operation of law either merge into the others or are vacated. I need to inform you, you have the right to seek post-judgment relief from your felony convictions by either filing a direct appeal to a higher appellate court or to file a motion for new trial. You have 30 days from the date I sign your sentence, which should be
Oh,
today
this,
or
just
tomorrow,
watch. Just watch. Something
to
happened. I
file a
don't know.
motion for new trial to any or all of the felony
Commotion
charges.
in this.
Mr. Clegg, are you going to file a motion for new trial? And
All I know is there's 3 guys. This is one of 3 who unalived a coach. Okay. And there was some kind of commotion in the courtroom at some point, and I think we're getting up on it. He's going away for life plus. So I just want to see what the commotion was.
notice of appeal.
I will file a motion for new trial within the next day or so, Your Honor. It will be up here in Boca.
Thanks, Tash.
Well, no, I would ask you to then appoint.
I know. Let's see what the commotion was. I'm all about the drama today. I'm in a weird mood today.
Certainly. Mr. Collins, you also have 4 years from the date your sentence is final to file a habeas corpus petition. And as Mr. Clegg requested, I will be appointing
I don't have a
you an
llama.
appellate
Somebody
lawyer.
get me a drama llama.
Your appellate attorney will
Shame
explain
me,
these
whatever.
processes,
Llama.
but I wanted
I'm
you
still waiting
to
on my.
be aware
pink
of the
octopus.
timeframes. Anything else, Mr. Clegg?
No, Your Honor, nothing else.
Okay, Mr. Collins can go with the deputies.
Where's the drama?
Whoa,
There it goes.
whoa. The family of Mr. Coleman. The family of Mr. Coleman.
Tash,
The
yay!
family of Mr. Coleman. Look at me. The family of Mr. Coleman. Honor Bradley Coleman here. Honor Bradley Coleman. He is never coming back.
No.
Nothing that happens in this courtroom is going to bring Bradley Coleman back. Okay.
Wow. Happy 1-month anniversary. I have loved having you as a part of this family. You are amazing. And we appreciate every one of you. So please always let me know when we have a celebration. We celebrate you today. Thank you so very, very much. Yeah, she just said that. I was like, what? You said what? Seriously? You just went there. But she's right. Nothing's going to bring him back. Honor his memory and don't act a fool. Now, we're going to do a little hopping because we have some new trials that are let me see the timer. We're 1 hour and 28 minutes in. I would like to find the opening statements to the Natalie. Is that how you say it? So let me. And day 1, we're going to go ahead and just kind of. We haven't watched all this trial. So let's kind of do some recapping so we all kind of follow along. We're going to do this trial, and then I have another live set up. So we're going to try this. I know a lot of y'all will hop off of this and onto another. That's fine. I want to have the verdict up on this one instead of going back and forth. We're going to try this. So what we're going to do is we're going to go into the opening statements of day 1 of this trial. I'll put it on the thing.
From the jury, ordinarily I would consider sending the bailiff out to retrieve her and bring her in. But under the circumstances, I don't think we want to have her as a juror in this case. And it looks like we will have to use
What? Let's
alternate
back
number 1.
that up all the way.
Trial of State of West Virginia versus Natalie Cochran, and it is case number CC-41-2023-F-343K. The record should reflect that all parties remain in place. The defendant is present. Let me explain to counsel and the defendant that we already have a juror problem. Ms. Bays in the clerk's office received in her junk mail an email from Ashley Evans. If you remember, she is juror number 3, whom we interrogated.
Why can't I get this to move? All right, it's just going to have to be there, guys. Sorry.
Lengthily yesterday. I will not read the entirety of this email, but basically she says that she's not coming. She has no reliable transportation. She said that her son has special needs and he is on virtual school and she can find no one to watch him or keep a fire. She has psychological issues and she is going to see Dr. Jaffrey today or tomorrow. And lastly, she talked to someone about the case on her way home against the court's instruction. So obviously.
In other words, Your Honor, she just doesn't want to do this and she's going to break every rule and use every excuse to get out of it. So she gone. She didn't want to have a part in this.
She has done everything she can to remove herself from the jury. Ordinarily, I would consider sending the bailiff out to retrieve her and bring her in. But under the circumstances, I don't think we want to have her as a juror in this case. And it looks like
I'd bring her
we
in
will
and make
have
her
to
answer
use,
for it.
alternate number 1 to step up and become.
Y'all, if I was a judge and somebody did that to me on my first day of trial with somebody, after I told them, do not speak to anybody, I can understand no transportation. I can understand that there's a child care issue. I can understand that you have maybe mental health conditions, but to purposely talk to people about this trial to get out of the trial, honey boo, we gonna have a conversation and it gonna hurt a little bit. I won't send you to jail, but it's gonna hurt a little bit. What is it with me and my accent today? I guess listening to him.
One of our regular jurors. Now throw that out to see if you have any
Hello, Miss
objections or
Morales.
suggestions.
Oh yeah, I'm
And
a
from
too,
the state,
Rachel.
Mr. Truman.
Your Honor, it's unfortunate that we are using one of 3 so early, but that's why they're there.
That's true.
Oatmeal, look how thin they are.
I think that bringing this juror in would be what I usually call an exercise in futility.
I
I
bring
think
her
we
in,
need to use
nail her to
an
the floor,
alternate,
and then
juror.
release her.
All right, and that's the court's view as well. Again, ordinarily, I would at least bring her in, chastise her, and perhaps even find her in contempt. Not because she has these problems, of course, but because she did not tell us about these issues that she had, and she has had a perfect opportunity to explain to us that she had difficulties. We were very cooperative and very considerate yesterday, and when prospective jurors had issues, we accommodated them as best as we could. So I propose to elevate alternate number 1, who is James Casey Bailey, to regular juror status. All right, are there any?
I would have brought her in and had her sit in the jail for the whole morning. I'd have her sit there behind bars all morning, and then on the lunch break, bring her in and explain to her the errors of her way and watch her run like a turkey day before Thanksgiving. I love that. Run like a turkey. I love that one.
Further matters that we need to discuss, and I'll turn to you first, Mr. Truman.
Okay, Your Honor, this would be before the first witness. We have two limiting instructions that the state.
No, let's just get to the opening statements, please.
These statements are neither arguments nor evidence and should not satisfy. All right, the state may present its opening statement. Mr. Truman.
Your Honor, before we begin, on behalf of everyone at the defense table, there is an extremely bright light behind you. I don't know if it's a reflection off of something, but it's very distracting from this point of view, and we're having trouble even concentrating. I believe it's a reflection off of a screen to your right.
Yes, this one,
Boy.
Yes,
this right here,
yes.
it's this, Judge.
What is
If it could be tilted or
Okay.
something.
it? Is there anything we can do about that? Is that going to affect
That's much better. Thank you.
broadcast media that we have here?
Fine, Judge.
And I can turn up these lights a little bit.
That was the problem, Your Honor. Thank you.
Okay. All right, now, Mr. Truman, you may proceed.
Thank you, Your Honor. Good morning.
Mama's okay. I'm
On
sorry. Did I
February the
startle
5th,
you? Mama's okay.
2019,
I'm okay.
Michael Cochran
Hi, yeah.
was a 200-pound, healthy 38-year-old man.
So.
By midday of February 6th of 2019, he had lost consciousness and he would never regain consciousness. He died in hospital.
I was wondering what happened to that.
5 days later, February 11th of 2019. How could this happen? Why did it happen? For an answer to that, look no further than this defendant's conduct. As you were told, the state has no direct evidence, the kind of stuff that makes TV shows exciting, the kind of stuff prosecutors love, jurors love. There is no DNA. There is no evidence of fingerprints. There are no videos of what happened. But as Judge Kirkpatrick will instruct you at the end of this, circumstantial evidence is just as valid as that type of direct and scientific evidence. And there is a ton of evidence of this defendant's guilt. All circumstantial. So how did this happen? How did this healthy 38-year-old man go into a state of unconsciousness and never come back from that?
Good question.
On the morning of February
Oh, can I
6th,
up the speed?
2019, this defendant advised her friend and neighbor, Jennifer Davis, that she had been sick all night, 103
I'm gonna try that.
temperature. And she had previously advised that she had cancer and was under chemo treatment. And that chemo treatment, the effects of which were somewhat negated by insulin. There were no diabetics in the Cochran house. And there's no evidence that this defendant was taking
I call
insulin
BS.
to counteract anything. But Jennifer Davis, being a good friend and the mother of a child who was a severe diabetic, had insulin. The defendant knew that. Jennifer Davis, being a good friend, sent her husband with insulin to the defendant's house that morning. About noonish, one way or the other, Michael Cochran collapses in the Cochran house kitchen. Now, the defendant gives various versions of what she saw, what she heard, and what she did, but there's no question that he was unconscious by about 12:20 or so. How do we know that? She took a picture of him and sent that picture to a number of people, showing him in a collapsed state in their kitchen. Did she call 911? No. Did she load him into a car and take him to the yard? No. What did she do? She called two construction guys that worked for her. They took Michael Cochran from the kitchen floor and put him on the couch, where he would remain for the rest of the day, some at least 6 hours or so. That's an unusual reaction for somebody to take with their spouse. She did, in addition to calling the construction workers, you'll hear from him, Jason Bowen, who helped move Mr. Cochran to the couch. She called a trooper friend of theirs, J.B. Hamilton, J.D. Hamilton came to the Cochran residence. He saw Michael on the couch. Michael was not conscious, and he was concerned. J.D. Hamilton is married to Stephanie Hamilton, and she is a physician's assistant. They get some medical attention. Stephanie Hamilton came to the house. She looks at Michael Cochran, and she tells her he needs to be checked. Did the defendant do that? No. Let him lay on the couch. Roughly 3 hours later, things have deteriorated to the point where Michael loses control of his bladder and urinates on himself. Did that event trigger any action by the defendant? Did it seek medical care for her husband, who's on the couch and unconscious now for a number of hours? No. She and her sister changed his clothes and left him on the couch. By 6-ish or so that evening, Michael's best friend, Chris Davis, comes to the house. Chris Davis takes charge. He says, we're going to the hospital. The defendant says, oh, he don't want to go. He don't want to go. Of course, nobody could ask him because he was unconscious. Chris Davis says, we're taking him to the hospital.
That's an automatic
They go to
go.
Raleigh General Hospital. But the damage has been done. You'll hear from a couple of doctors to explain the significance, but for now, just keep these numbers in mind. According to the defendant, Michael Cochran's blood glucose level was in the 140s during the day. She reports that to a couple people. He gets to Raleigh General Hospital, and it was 21. 21. That may mean nothing to you right now, but keep that number in mind. Now, Michael Cochran's mom was 10 minutes from his house. She's a retired, registered nurse. Did the defendant contact her? Oh, she did, about 10 o'clock that night by text, saying, they're going to have to take Michael from Raleigh General to CAMC. All the opportunities to get help to this man, and she took none of them.
Yeah, Rachel, that's
After being
serious.
in CAMC for a few days, he's transferred to hospice. He's there roughly 5 hours and dies. His cause of death was damage to his brain caused by insulin. You'll know that because a couple of doctors will testify. A Dr. Rebate and a Dr. Krieger will tell you how the effects of insulin just basically destroyed this man's brain. Glenda Epperly, an experienced RN and a hospice nurse, said she had never seen a body come out of hospice that looked so good. This was a healthy man until she did him in. Now that answers the how. Why? Why would this happen? And why would it happen when it happened? Well, as the defense counsel informed you during questioning, the defendant had run a Ponzi scheme, a big one, where millions of dollars were taken from friends, relatives, local professionals. As many deceptions and lies as were told to her victims of the Ponzi scheme, Michael Cochran was told just as many. He did not know what was going on, but he was determined to find out because people were saying, hey, we invested in your company in this plan and we're not getting our money back. And he was frustrated. He was very frustrated. But the same excuses provided by the defendant to all of her victims in the Ponzi scheme were being provided to Michael Cochran too. It's everybody's fault under the sun. They've got hundreds of millions of dollars in their money stuck in a bank in Virginia, Bank of America. That's what she told Michael Cochran. That's what he believed. So Michael Cochran is going to straighten this out. They charter a flight from Beckley to the Bank of America branch in Lynchburg, Virginia for the 6th of February, 2019. Mysteriously, the defendant cancels that trip in early morning hours. Why was that trip so
Why?
important? Because Michael Cochran and everybody else would know at that point. There is no money in the Bank of America in Virginia. There's never been any money in the Bank of America in Virginia. There are no government contracts, which is what she was selling to the most of Raleigh County, it seems like.
She got
Those
11 and a half
were
years
fictitious things
for
she
that
made up
crime.
and built millions of dollars out of her victims. Now, we're not going to pretend Michael Cochran didn't get a benefit from this. He did. The defendant and her family lived a very lavish lifestyle with other people's money. And Trooper Heinzman will explain to you in an overview, because this case isn't the Ponzi scheme case. That one's over. This is a murder case. But he'll explain to you how the defendant did this and how she was able to pull this off for so long and how she got so many people to forfeit their money to her. That was all going to blow up on February 6th. And it would have been over February 6th. But of course, the Cochrans never made it from Beckley to Lynchburg. And Michael Cochran is dead.
I'm on the
because of
fence
this.
with you on that one.
By the way,
By the way, y'all go
in case
into
you've
the
forgotten
poll.
from some of your questioning,
Right now
this
we
defendant
have
is a pharmacist. She
73%
knows
guilty,
about medications and drugs.
27% not guilty.
She held herself out as a specialist in diabetic counseling. She knew the impact insulin would make. That's our case, all circumstantial. And at the end of it, we'll be asking you to find.
See, if she is a diabetic counselor and specialist, why would she not have noticed his condition was contributed to low blood sugar? You know what it looks like. You're a specialist. You would know that there's something seriously wrong and then need to get him to the ER. Why did you not take him? If he's that lethargic, that unresponsive, that a sternum rub and a foot scraping, I call it, the bottom of the soles of the feet, you run your toenail or bottom of a pin or something up like that. Why would you not have called 911? I don't care if he's going to kill me coming out of it. He's alive enough to do, he'll be alive to do it. So yeah, I don't know exactly. I'm not going to argue how or when or where she did this, but that in and of itself pisses me off. She is obligated under federal law to call 911. And she didn't. You can have a seizure-like activity with your blood sugar that out of whack. If you don't remember the movie Steel Magnolias, where she's sitting in the chair and her Shelby's sugar is out of control and she starts thrashing around and it was too low and they had to give her some orange juice. That can happen. My father was a brittle diabetic. You get confused, you can shake, you can convulse, you can do a lot of things. So I agree that, she should have known better. If she is as qualified as she said she
Find the
was
right
in
verdict
diabetic
and find the
knowledge.
defendant guilty of first-degree murder. Thank you.
Diabetic seizure. Not a seizure.
May I please
Sorry.
report? Counsel for the state.
I need to apologize to you guys today. I'm keeping the lights kind of down today. I'm not feeling 100%, and I'm just going to make sure that I don't pop into a migraine.
Ladies and gentlemen of the jury, by the prosecution's account, and perhaps by some other
Hey,
accounts,
Penguin! We're
Natalie
calling him
Cochran is not a
Penguin.
nice person.
Thanks, Broken Baker, for that. That's perfect.
she defrauded friends, relatives, investors. She was involved in a Ponzi scheme. She cheated, she scammed. And she has paid for it. But ladies and gentlemen of the jury, the fact that she is perhaps a fraud and perhaps a cheat, and that you wouldn't perhaps want to invite her home for Sunday dinner, that you wouldn't like her, does not translate into being a murderer. This trial is not a forum on public acceptance. You don't have to like her. You don't have to say she is a great person. But you have taken the oath to judge her fairly and to give her a fair shake, a fair trial. When you took the oath, it's not just some wave of a hand. It is a solemn oath to search for the truth and to determine.
We are now at 1 hour
really
and
happened in this
49
case.
minutes.
Now, the prosecutor presented a very nice theory. except that as you, well, people do that. Again, I'm Matthew Victor. I represent Natalie Cochran with my co-counsel, Mr. Stanley Selden. We represent somebody, again, who is perhaps dishonest in her financial dealings, but who didn't kill anybody, let alone her husband, her only man in her life, a man, father of her 2 children, and a man with whom she was enamored ever since she laid eyes on him in high school. She's not a murderer, as the evidence will show. Now, she is accused here by the state of West Virginia of one of the vilest crimes there is known.
No,
And I will submit to you
no.
that the state's
Don't,
motive in
don't
this case,
exaggerate,
as they
Boo.
presented to you, is absolute nonsense. The state of West Virginia is trying to tell you that my client, Natalie Cochran, who has lived with the man who was up to his eyeballs in the policy scheme, somehow detected that he was on her.
Howdy.
He
Welcome, y'all.
was already
Hi,
detecting
Yana.
that she was committing a major fraud, and he was going to run straight to the federal government.
Well, I'm looking at their live,
Well, think about
and
it, ladies
it's
and
not.
gentlemen, as you
It's
listen to the
still
evidence.
live. When they
State
come in,
won't
thank you,
believe
Yana.
that he
Um,
didn't know
I
anything
got their
about the
live
Ponzi
up.
scheme,
When they pop
didn't
in,
know
I'll
anything
switch
about
over.
millions of dollars in the lavish lifestyle. He didn't know anything about this, even though the evidence will show that he was signing all these contracts, he was working on the contracts, he was signing checks, and you will see that evidence, you will hear that evidence. And all of a sudden, he found out that Natalie Cochran, his beloved wife, is a fraud and a cheat. And what was he gonna do? No, he was not gonna go and talk to her and try to resolve this case somehow, get a lawyer. No. The evidence will show, well, at least the state's evidence will show, that she's going to run to the federal government and turn her and her in and have the dear,
Okay, yep.
dear wife, the mother of his
Verdict.
children.
There is a
Well,
verdict,
fucking
but
listen.
they've not
Well,
come back into the
okay.
courtroom.
Think about that. As you listen to the
Okay,
evidence,
let's look at somebody else's live.
be aware of the fact that she, that is, Ms. Cochran, does not have to prove herself innocent. The state has the burden of proof, beyond a reasonable doubt, to demonstrate that Natalie Cochran killed her husband with premeditation, deliberation, and malice. And that
The
ladies and
verdict
gentlemen
is in
of the
less
jury,
than
the evidence will
2
show the
hours.
state cannot do it.
Y'all, that's going to
They
be a
cannot do it.
guilty.
You will see
Then they got to go in and do
exhibits,
the
you will see
sentencing phase.
documents here, consider it all. But what comes to mind immediately,
The problem is the defense side says it's going to take it till the next day to get some of their witnesses there for her on the defense for the sentencing phase. So they're going to want to push it off. They're trying to push it off till tomorrow.
is
Give
that
them more
bottle
time
of
to
insulin.
prepare.
And I will submit to you that this is a smokescreen that the state is going to present to you. You will hear expert testimony and evidence that this type of insulin could not kill anybody. And for that matter, that
Oh,
the amount
bull.
of insulin that may have been given to Michael Cochran would not kill
I
him.
call BS.
The state will not tell you exactly what happened that day. Well, they will tell you what they believe happened that day after Mr. Cochran was allegedly shot with this insulin. But what they will not tell you is that if you are shot with a injection of insulin, you're not going to drop unconscious immediately. Think about what would happen if somebody injected you with insulin. Would you react? Would you call 911? Now let's think about it. Let's also think about the fact that
That
the
much
evidence in this
insulin?
case is
Yeah.
not exactly what the state believed you to be. Mr. Cochran was a 38-year-old man who died, and the question still remains, what did he die of? You will hear medical evidence that Mr. Cochran was not a healthy 38-year-old man. In fact, to the contrary, between the late 2017 and the time of his death in 2019, he was in the hospital 4 times. For what? For life-threatening conditions. He was a ticking bomb, the evidence will show, health-wise. He suffered from a plethora of medical conditions that could easily end up his life. What's more, you will hear the evidence that Mr. Cochran fancied himself to be a bodybuilder. He wanted to be the Arnold Schwarzenegger, Mr. Universe.
The third judge of the Circuit Court of Raleigh County is now sitting.
All right, here we go, y'all.
All right. I'm advised that the jury has a verdict. All parties are present and the defendant
Less than
is
2
here.
hours, boo.
I'll expect no outbursts when I read the verdict one way or another, and I will direct the bailiffs to escort anyone out who violates this directive. Are there any matters that we need to discuss before we bring in the jury and receive the verdict?
Please state, Your Honor. Thank you.
No, Your Honor, thank you.
Bring in the jury.
So, honey boo boo, get ready to spend the rest of your life in jail. That was real quick. And any defense person's going to tell you the quicker they come back, the worse it is. Unless it's such an unanimous not guilty, which is a lot rarer than guilty. This is just a very nerve-wracking moment for all involved, all attorneys, both sides. Her heart is racing 1,000,000 miles a minute. Her heart's racing as fast as a turkey on the run. I'm never going to forget that. That judge is funny. I love the Southern colloquialism. I'm not surprised. Sausage and biscuits this morning? Oh, Your Honor, did you buy them or did
Madam
you bake them
Foreperson, has
yourself?
the jury reached a verdict?
Homemade sausage and
Would
biscuits.
you hand that verdict to the bailiff who will transmit it to the court?
Transmit it? I am in a very quirky
Would the
mood
defendant
today.
please rise?
Y'all be forewarned. I'm quirky today.
In the case of State of West Virginia versus Natalie
Scared to
Page
death.
Cochran, case number 23-F-343K, the jury verdict is as follows. We, the jury on the issues, joined unanimously find the following.
Guilty.
The defendant is guilty of murder in the first degree.
Yep.
The verdict form is signed by Holly Rich, foreperson of the jury. It is dated 1/29/2025. There are no marks on the portion of the verdict form pertaining to involuntary manslaughter. Does the state wish to examine the jury verdict form?
No, thank you.
Does the defense?
No, Your Honor, thank you.
You may be seated. Is there a request for the court to poll the jury?
Not from the state.
No, Your Honor.
All right. The verdict is received by the court and directed to be recorded. I'll ask the state to prepare an appropriate order in the premises. The court accepts the jury verdict and finds this defendant guilty of murder in the first degree. The defense will be afforded time to file all appropriate motions. And as we discussed earlier, we must have further proceedings concerning the aspect of mercy. I would like to do that right away and perhaps to commence this afternoon. I can afford the defense or the state 2 hours to prepare, and we can go directly into the mercy phase.
Your Honor, as we pointed out to the court, we cannot have our witnesses prepared in 2 hours. Specifically, we anticipate calling the children. They
What?
are not close by at all. They're in school.
Well, Matthew, no. What? I can't hear you.
Children?
I've been corrected on that particular point,
Oh,
but
good.
we have to get in touch with our other witnesses. It will take considerable time to do that. We have to make sure they can get here.
You should
And
have
we
been prepared, boo.
Respectfully request
You should have
to
been prepared.
continue these proceedings and have the mercy portion sometime tomorrow.
What saith the state, Mr. Truman?
You should have been
Your
prepared,
Honor,
boo.
the state's prepared to go forward. We understand the defense situation. If they could proffer a number of witnesses they're going to have, that might be helpful. And if they can't start out today, then we defer to the court's judgment.
All right. Members of the jury, let me explain to you the circumstances. You have found the defendant guilty of murder in the first degree. There is another aspect that you must consider, and that is whether or not to afford to her mercy. If she receives mercy, she will be eligible for parole in 15 years. If she does not receive mercy, she will spend the rest of her life in prison. And that is a decision that you must determine. We must have a mini trial, so to speak, further proceedings for you to hear additional evidence in that regard and make a determination. You will have to return another verdict in regard to that matter. So the upshot of the situation is you are not finished with your responsibilities. And it is perhaps unfair to start into this right away and to force the attorneys to proceed in this very critical and important part of the proceedings. So it is such that we're going to start up at 9 o'clock in the morning. And I hope you'll understand, and I hope that you will continue to be cooperative and patient and considerate and proceed as you have already. You have been here promptly and you have provided service as jurors in the manner expected and the manner certainly I request. So here's the deal. I must still warn you and admonish you not to read anything, hear anything, talk to anyone about this case. And by anyone, I'm talking about your family members or friends, because tomorrow is another day insofar as you all are concerned. And we will proceed further in regard to the mercy phase of this case. So you're not done, and we need for you to come back. And you may be sad about that, or maybe you're okay with that. I don't see anybody throwing tomatoes at me yet. So hopefully you'll understand. We need to finish this out. We have much time invested in it, and we simply need to bring it to a conclusion. And I will need you back.
Well, I'm
in
going to
your
have to
jury
do a double
room,
live tomorrow, and that's
at,
going to
9 a.m. I'll try to have a treat for you as a bribe for you.
a
to
treat
come
for
back.
you as a
And
some
please,
homemade biscuits and
follow my
gravy.
instructions. Don't watch anything on TV or see anything online. Again,
Biscuits and
for
gravy.
the purpose of this additional phase, I want you to have an open mind and to hear the evidence so you can make this additional determination. I can't tell you anything as to what you must do in regard to mercy, but if you have any questions about the procedure or If you want to curse me, now would be the time to do that.
Can we just fry her?
I don't see any curses, and I don't see anybody complaining too much. All right, I will need you back in your jury room tomorrow by 9. Anything further before I let the jury go for the day from the state?
Not for a state, right?
From the
No, Your
defense.
Honor.
That
Thank you.
means 8
All right,
o'clock my
you
time.
may follow the bailiff to your jury room, and I'll see you in the morning at 9 a.m.
Oh, yeah. Honey boo, they should have been prepared. The defense should have been prepared for this. That's part of being a lawyer. That doesn't look too bad. Just double checking something out.
All right, we will start up for the mercy portion of this case in the morning at 9 o'clock.
9, okay.
The defense will go forward first,
8.
sort of an unusual arrangement. There is no burden of proof. And it's sort of the wild, wild west, more or less. The court will be very lenient in terms
You're in West
of
Virginia.
evidence to be presented. The only thing that I'm bound by is rules 401 and 403 of the rules of evidence. 401, of course, relates to relevancy. 403 requires the court to engage in the balancing to make sure that the probative value of any evidence is not outweighed by its prejudicial nature. Other than those restraints, the court can consider prior bad acts. The court can consider character. The court consider habits. Almost anything
gonna
that
come
would be
in now.
relevant and not unduly prejudicial to the defendant. So you are guided by that instruction, and we will start up.
And she's
for the
still
mini
wearing a
trial
wedding ring?
in the morning at 9 a.m. Are there any questions or suggestions from the state?
Not for the state, Your Honor. Thank you.
Anything from the defense?
No, Your Honor.
You were going
All
away
right,
for life, boo.
Court is in recess.
Y'all, that is a scary as heck feeling for her right now. She's going to have a very bad couple of nights. And she's already serving 11 and a half years for the fraud case. And, honey, why's that woman following her? She can't go back there. I guess they can. All right, guys. What we're going to do is I'm going to close up this stream in a minute. But before I do, we're going to do the giveaway. Wait, let's get back over here. I do like to watch the reactions in the court. I mean, it doesn't fix everything, but it does bring some finality to the situation for the family. I have zero sympathy. Yeah, exactly. Thank you, Benny. Thank you. Okay. How far out am I? I think they're starting at 11:30. Let me do this. I'm going to do a redirect. Give me a split second, y'all. I'm going to do a redirect. I've got to set it up. There we go. I'm going to save. Awesome. Got it set up. So what I'm going to do is we are going to do the drawing for this trial. And that's one of the children standing there. One of the children. How can I get rid of this one? I want to delete this one. Can't. Oh, I hate it when you trying to do something and it won't let you. I got to go to the back office and go the long way. All right, got it done. Okay, so now, oh, those are her children. So why did they need to put it off for till tomorrow? That's good. So now he's just telling them what's going to happen to her and all that. So unless something interesting happens, let's go ahead and do the giveaway. Or the entry pool for the giveaway. Tash, congratulations. Now, if y'all go to the other feed that I'm getting ready to do right now, I'm going to go live over there in a minute. And we're going to probably read some Karen Reed stuff. I need to do a Karen Reed live. We'll do that. Congratulations, Miss Tash. Congratulations. You were in the drawing. So, long and short of this, she was found guilty of first-degree murder. No mercy there. I am so not surprised at all. There were a few things that made me kind of be on the fence, but in the end, her knowledge, her understanding of diabetes is what nailed it for me because she knew. She knew. I just want to ask her how did you do it? How did you get it in him without him coming after you? And by the way, if anybody watches Broken Baker, go tell him to have a look at me today because I was raised on Dolly. I blinged and beaded this myself. I bought the hat and I did the work on it myself. This is some of my bead work. I know the camera's kind of wigging out on it. Let's see if it will focus on it. There it is. So anyway, they're sitting here. Oh, they're still live? Why is the stream still live? Okay. They still live. Don't know why, but they is. Oh, now they go to the okay, fine. Whatever. Okay. I'll take that off. Put me back. Okay, guys. So we're gonna teleport, transport over to the other live, which should be starting shortly. Actually, I need to start the live before we can go over there. So let me get that one up and going. So this case is going to continue tomorrow morning. For the, as they call it, the mercy phase, we call it the sentencing phase. Oh. Did I schedule it for 9:30 instead of 11? I guess I did. Oh, well, we'll go live now. We're going in there now. Here, I'm going to put it over here so you guys can see all the peddling that I have to do to switch over to the live. That's that giveaway. Taking that down. That's this one. Here's the new live over here. Add to stage. Y'all, this is a lot of work. I ain't that fancy, y'all. Now I have to open up my live. I don't know if y'all can see all this dancing I'm doing. I have to come over here and open up my live that I'm going on now. That's day 1. Where's my live? There we go. Pop out chats. Put that over there. I mean, this is you can't, it's not easy just switching over, y'all. It's not easy just switching over. Okay, guys. So I'm going to go live on this one. Actually, let's move that one here. This one there. What's behind it? Oh, old chats. I'm going to delete that. Yeah, this is a lot of, it's like they say, the duck, it's smooth on top of the water, but it ain't smooth under the water. Okay, I'm going to go live on this one. And I'm going to close this one down during the intro. Okay, guys. Thank you so much for joining me. I appreciate you. Y'all have an awesome day. Come join me on the other live. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.